Judgment in the appeal SXH and the Crown Prosecution Service.
Lord Mance will explain the judgment of the court.
In deciding whether to institute criminal proceedings, the Crown Prosecution Service, the CPS, is required to apply a two-stage test. It must first consider whether there's enough evidence to provide a realistic prospect of conviction, and if so satisfied, it must then decide whether the prosecution would be in the public interest. Under Section 25(1) of the Identity Cards Act 2006, it was an offence for a person to be in possession of an identity card relating to someone else with the intent of using it to establish his or her identity as that person's identity. However, individuals fleeing persecution may have to resort to the use of false papers to make good their escape. Therefore, under Section 31 of the Immigration and Asylum Act 1999, which gives effect in domestic law to the International Refugee Convention, it is a defence for a refugee who is charged under Section 25 of the Identity Cards Act 2006 if he came to the UK directly from a country where his life or freedom were threatened and made a claim for asylum as soon as reasonably practical. Directly has here been given a purposive interpretation so that this defence is not excluded by a short-term stopover in some intermediate country. The appellant was born in Somalia, where, as a member of a minority clan, her life or freedom were threatened by majority clan members, and indeed both her mother and father were murdered, and the appellant herself raped and severely beaten. In December 2008, she fled from Somalia to Yemen, and there she spent a year before travelling on to Holland, to which she flew on a false passport. And then from Holland, she flew to the United Kingdom. She was challenged by the UK Border Agency on arrival and immediately claimed asylum. The next day, after an initial screening interview, she was arrested on having suspicion of having committed an offence under Section 25(1) of the 2006 Act. The CPS concluded that the evidential and public interest tests were satisfied. She was remanded in custody, and despite consideration of her case over the next months, she remained there until mid-2010, some nearly 6 months. During the consideration of the case, the CPS advocate did research the position of Somali refugees in Yemen and eventually found that although Yemen is a party to the Refugee Convention, its procedure for bringing it into effect was poor, so she couldn't really be expected to have claimed asylum there. And the CPS advocate concluded that, subject to her being eligible otherwise for asylum, the prosecution of the appellant should not continue as it was not in the public interest. She was on the 10th of June granted asylum, and the following day no evidence was offered against her at a mention hearing in the Crown Court, and she was found not guilty and released from custody. She then brought proceedings against the CPS, Home Office and the police for damages on various grounds, including alleged breach of her rights under Article 8 of the European Convention on Human Rights, which protects and requires respect for private life by public authorities. The claims against the Home Office and police were not pursued, and the High Court dismissed her claim against the CPS on the ground that the decision to prosecute could only engage Article 8 if the prosecution targeted an activity which could credibly claim to be an exercise of an Article 8 right, and presenting an immigration officer with false papers was not, in the High Court's view, an activity that formed part of her private life. The Court of Appeal upheld this decision. The Supreme Court now unanimously dismisses the appeal. Lord Toulson, with whom Lord Mance, Lord Reid and Lord Hughes agree, gives the lead judgment. Lord Kerr gives a concurring judgment. The reasons for dismissal are that although Article 8 is broad, it doesn't encompass everything done by a public authority which has a consequence of affecting someone's private life in some more than minimal way. Neither Strasbourg nor domestic case law supports the contention that the institution of criminal proceedings for a matter which is properly the subject of criminal law and for which there is sufficient evidence can be open to challenge on Article 8 grounds. It would be illogical, for if the matter is properly the subject of criminal law, it is a matter for the processes of the criminal law and for the criminal court to consider. In this case, the decision which is challenged is the initial decision to prosecute. However, it is accepted that the offence under Section 25 of the 2006 Act complies with Convention rights, and it was conceded in the courts below that the CPS was reasonably entitled to take the view that the evidential tests were satisfied when the decision to prosecute was taken. It is difficult to envisage circumstances in which the initiation of a prosecution against a person reasonably suspected of committing a criminal offence can itself be a breach of that person's human rights. Prosecution is not, of course, obligatory in the United Kingdom. It's a matter of discretion. But whether it is in the public interest to prosecute is not the same as whether a prosecution would breach an individual's Article 8 rights. Article 8 is not therefore applicable to the decision to prosecute, which in itself simply places the question of guilt or innocence before the court. It would be different if the state had deliberately trumped up false charges. This would involve the torts of malicious prosecution and or misfeasance in public office, to which Article 8 would, however, add nothing. The CPS may be criticised regarding the length of time taken to conclude that the Section 31 defence would succeed, and Lord Kerr raises the possibility that the continuation of the decision to prosecute, beyond the time that it should have been recognised that the appellant had an answerable defence under Section 31, constituted an interference with the appellant's freedom of liberty under Article 5 of the Convention, as well as Article 8 rights. But the case wasn't presented on that basis, on which other members of the court expressed no views, since the focus of the claim has always been confined to the initial decision.
The court is now adjourned.